people of the Kulin Nation, and I pay my respects to their elders past and present. I had forgotten about 95% of what you introduced me as doing. It's quite remarkable the amount of research that has obviously been done into my background. I chose the top. Oh, I'm sorry. Is it better? I was asked what topic I would like to speak on. It had been suggested to me that I speak on access to justice, but I thought perhaps the best way of approaching such a topic was to speak on what was happening in more recent times in the Magistrates Court of Victoria. So I chose the title, Recent Developments in the Court. There are some developments that are inspired internally in the court, and some that have come more recently through the latest state budget. One of the developments that's happening now, and has been happening for the last few years, is the increasing use by the court and by the legal profession of an audio-visual linkage between the court and somewhere else. The driving force behind this was an occurrence that was unique in my experience anyway. It arose in late 2013 when we had persons in custody not being brought to the court in response to our remand warrants or our jail orders. That is, that we had made an order of one sort or another that a person would be produced from somewhere in custody into our court on a particular day, and it did not occur. That was due very largely to the aftermath of the murder of Jill Maher and the changes to the parole system in Victoria, which led to a large number of people having their parole cancelled and going into custody. This put so much pressure on the system and the various bodies that brought people to court that people were not being brought to court. We as a court made a conscious choice. Instead of saying to the executive government, it's your problem, you fix it, and seeing what I would have thought would be chaos in the system, we devised a number of measures which we thought were interim in order to overcome the problem. And by and large, we were successful up until the disturbances at the Metropolitan Remand Centre in July of last year, when a lot of this work was really undone. We introduced for the first time in this state weekend sittings of our court. That is, the court at Melbourne sits each of Saturday and Sunday with a magistrate on each day, dealing with people who have been refused bail and arrested after 3 p.m. on Friday and up till 3 p.m. on Sunday. The court hears about 20 to 25 cases on a Saturday and about 20 cases on the Sunday on average, and deals with those persons. About a third of them are granted bail. We made a change with the catchment area for the court at Sunshine. Some of you might practice in that area. What we did was, Sunshine was the most affected of the venues of our court by this non-production issue, so we brought a lot of their cases into Melbourne, or mainly into Melbourne. So we changed the catchment area so that people in Footscray were coming to Melbourne rather than going to Sunshine. We reached an agreement with the County Court at Melbourne whereby we would use their cell facilities and also, as a result, use 2 of their courtrooms on a daily basis. This was mainly aimed at bringing protected prisoners into the system and female prisoners. People who are, say, female prisoners or females on remand have to occupy a cell on their own. They can't share a cell with a male. Since there are many more males than females on remand, it meant that if there was a female, we lost at least space for 4 men. So we introduced that scheme, and that's still running. We also had a variation of our Court Integrated Services program, which is an elevated bail support scheme, which we call, and the variation is called CROP, where they place these people in custodial facilities and they assess people while they're in the prison or on remand, and so we have the information available when the matter is brought to court and a bail application has been made. But they're all interim measures, and they've been effective in their own way. Our longer term vision was that we would boost our audio-visual system. The audio-visual system we have was introduced in the mid-1990s. It's a telephone-based system. It's very clunky. The reception is poor, as my magisterial colleagues would acknowledge. So what we got the state government to do in 2014 was to fund a first stage of a modern internet-based system. And in the state budget in 2015, monies were provided to run this system out statewide. And that means that every venue of the Magistrates Court in Victoria by the middle of next year will have internet-based audio-visual links wherever the venue is, whether it be fixed systems or whether it even be just mobile systems. Our feeling is, or my feeling certainly is, and it's the view of the court, that too many people in custody are brought too often to our courtrooms. That is already, as the system is being run out, that is already showing signs of being very effective. For instance, in February of this year, magistrates ordered persons in custody to appear by audio-visual link in 313 cases. That had risen to 870 in May. So the number's going up dramatically. The next step in this is to change the law, because the law in relation to audio-visual links is very restrictive. It's law made for a system of the mid-1990s, and it's mid-1990s law. There is a bill in Parliament which we've requested be put into Parliament that has passed the lower house, in which it will reverse the presumption. There will be a presumption in criminal cases that a person in custody will appear in the court by an audio-visual link. That presumption won't apply in four distinct circumstances. If the person is being brought to the court for the first time, if the person is, if there's a fitness to plead argument involved, if there is a defended committal hearing, or if there is a defended summary hearing of a criminal matter. Other than that, there's a presumption that the person will appear in our court by an audio-visual link. That, of course, is always subject to the overriding decision or discretion of the magistrate hearing the case, and he or she can override that presumption in the appropriate circumstances and in the interest of justice. That bill, with the quaint name Justice Legislation, Evidence and Other Acts Amendment Bill of 2016, passed the Legislative Assembly on the 9th of June, entered the Legislative Council on the same day, and I expect it to be debated in the Council later this month. We would, if it's passed by the Legislative Council, we've suggested to the Executive Government that it be proclaimed to operate on the 1st of September, because by then all this new audiovisual equipment will be throughout the Melbourne metropolitan area and will be starting to be placed in country venues. It's interesting that my magisterial colleague Tony Parsons is here today, and he could probably speak to this next issue better than I could, frankly. But as you may be aware, in the last state budget, the one in late April, money was provided so that the drug court could be expanded to Melbourne. As you may be aware, the drug court was created in 2002 and it was placed in the Dandenong area. And it's really just, well, it's up until recently anyway, it's just stayed in the Dandenong area. The drug court aims to deal with those persons who have serious entrenched drug addictions who are committing significant offences, criminal offences. And as far as I'm concerned, I dare say Tony shares this view, for those persons, the drug court is really the only viable option outside of imprisonment. For those persons, you would imprison them unless you have a drug court that can be made available for them. And the drug court is very successful in this area. When you bear in mind who you're dealing with, it's successful in 40% of the cases. I dare say most other drug treatment processes would have a success rate of 3 or 4%. The drug court is far, far better than any of those. The drug court has expanded to Melbourne, will be 2.5 times the size of the drug court in Dandenong. And when they're both fully operative, the drug court at Melbourne and at Dandenong, in my view, will make a significant difference to the criminal justice system. I can foresee that a significant number of people who are real offenders in this area being treated successfully through the drug court and being returned to society as useful members of society, rather than just going through the swinging doors of prison back and forth and committing offences. The next issue, and I'll deal with two issues together. As you also are probably aware, the Royal Commission into Family Violence delivered its report on the 29th of March this year. It made a total of 227 recommendations, of which about 27 directly affected the Magistrates Court and the Children's Court. A number of others affected both those courts indirectly, and a large number of other recommendations affected the broader justice system. From the Magistrates Court point of view, the key recommendation was recommendation 60, which recommended the expansion of our Specialised Family Violence Court. We have a Specialised Family Violence Court which operates at Heidelberg and at Ballarat. We call it, or it's called in the legislation, the Family Violence Court Division. What the recommendation says is that this should be expanded from 2 venues of the court to 14 venues of the court, and all being major venues of the court. So in effect, if the recommendation is carried out, we will have a specialist approach in family violence within the court across the state. And in fact, recommendation 61 says that the specialist approach should be adopted for all family violence matters within 5 years, unless the circumstances are exceptional. So the recommendations, those 2 recommendations together will mean, if implemented, will mean that the way the court addresses family violence will be done through a specialist model. And by a specialist model, I mean that there will be specialist magistrates involved, there will be specialist registrars, there will be specialist support workers. We have applicant and respondent support workers. There will be specialist police prosecutors or civil advocates from the police if they're required. There will be specialist lawyers, specially provided, say, from Victoria Legal Aid, but from the profession as well. So the whole approach will be a specialist approach. It's very much modelled on the American-style domestic violence courts. We would very much like to, in this specialist model, adopt the American style of one judge, one family. That is, that from go to woe, the particular judicial officer deals with all matters related to that family, coming first to the court through family violence. There are limitations in Victoria or in Australia, because in family law, that's the province of the federal government, and I note that there's 2 members here, and it's not a matter that state law can affect. But one of the recommendations was that we increase the awareness of the Magistrates Court's jurisdiction in family law, so that more applications could be heard within this specialist model, even under the Family Law Act. So that's the major recommendation 60 is the major recommendation, and the second major recommendation was recommendation 70, which will cost the government a lot of money to implement, because it recommended that we bring up to a certain standard all the major venues of our court so that they are safe for people involved in family violence. Now, a lot of the venues of our court are very old. They were built in the 1860s or the 1870s or the 1880s, where family violence was not even recognised as a concept. So to make these facilities safe for people will require a significant investment. As an example, the court at Heidelberg was badly damaged by water in February of last year. We've been repairing it, and we've also been putting some money into it in order to create modern, safe waiting areas and other facilities for family violence persons. As you're aware, the Heidelberg is a division of the court, of the Family Violence Court Division. It reopens on the 25th of July, and I suggest that any of you who are interested in seeing what can be done for family violence and creating safe waiting areas and creating facilities that will make the court itself safe for people involved in family violence, go and have a look at Heidelberg when it reopens for business fully on the 25th of July. Have a look and see what can be done as the best example to date in this area. So they are really the issues that I wanted to touch upon. The state budget, the last state budget, provided a good deal of money to our court in relation to making it safer more broadly. Most of the venues of our court, certainly in the country, but also in the metropolitan area, a number of them, do not really have very safe environment. There is no X-ray type machines at the entrance of the court. There are very few security officers, and that's virtually non-existent in the country. The last state budget provided sufficient monies so that every venue of the court, whenever sitting, will be able to have security officers present, will be able to have some form of X-ray machinery or wanding or other devices that would detect unfortunate weapons. In addition, the budget provided for upgrades to 14 country venues of the court to make them better, safer for all involved. The only other thing that I wanted to mention, and I only thought of this when I was listening to everyone making a welcome to country. As you're aware, recently Professor Patrick Dodson pointed out to all of us and reminded us all of the dreadful statistic in relation to Aboriginal persons in custody. I think we've all been conscious of it, but he really underlined it and put it into strong terms. The reality is that the Royal Commission into Deaths in Custody in 1991 made a large number of recommendations, but they seem to have had little effect in Victoria and elsewhere in reducing the number of Aboriginal persons in custody. I think when the report came down, there were 11 times as many Aborigines in custody as a proportion of the overall population. The figure is now 18 times. We have a Curie Court in Victoria. It operates at 8 venues around the state. It makes a significant contribution to reducing the number of Aboriginal Curies in custody, but it's really only slowing the process, and it would be worse without it. But we're trying at this stage to introduce or to bring more Curie offenders into our diversion scheme. Very few Curies enter our diversion scheme operated through the court. Less than 0.5% of the persons who undertake diversion in our court are Curies, even though they make up 3% of the population, and as I've mentioned, a much larger percent of the overall prison population. So we're going to introduce, completely unfunded, we're going to introduce a Curie diversion list at 2 of the major venues of our court, Melbourne and Mildura, the major venues that deal with Curie offenders. That is, and that'll run as part of the Curie Court itself. So we're expecting a greater number of Curie persons to be brought to our court seeking to be diverted rather than go through the criminal justice system in its normal form. So look, on that really happy note, I'll end my speech. Thank you.